It's the source of our government. It's the source of the nation's biggest fights between the government, the states, and the people. It's the source of our unique pride and the standard that we measure ourselves against the world. Intended to ensure life, liberty, and the pursuit of happiness, it provides both the foundation and the aspirations of our society. It's the U.S. Constitution. Welcome back to Law Dogs. I'm your host, Jeff Henley, and with me as always is my girl, Annabelle. Today, we're taking our first look at the U.S. Constitution. No American can make it through high school without learning about the miracle at Philadelphia. The birth of our Constitution, the debates that surrounded it, and all of the things that came along with it. Now, we're not going to be doing a history lesson here at Law Dogs, but what we are going to be talking about is the litigation of the powers associated with the Constitution and all of the things that come along with it. When you're talking about the Constitution, you're talking about the interaction of what we call the supreme law of the land and every other law, ordinance, statute, or rule that governs our society. Any introduction to the Constitution must make mention of the Supremacy Clause. Found in Article 6, Clause 2, the Supremacy Clause states, "This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding." The Constitution is the supreme law of the land, but it's more than that. As its name suggests, it is what constitutes the entire government. The Constitution itself is rather small. It is only 4,543 words long, and in fact, it'll fit in your pocket. It is something that, despite its small size, governs every facet of our entire legal system in the United States. Now, I have not even mentioned the 27 amendments, the first being the 10 in the Bill of Rights and the 17 that followed thereafter. But all of these things, the 7 articles and the amendments, are parts of this document, this great document that has touched and concerned every facet of our lives and will control all of the laws that govern us. In our investigation in Law Dogs, we're not going to be talking about just the history. You will certainly get some of those things, but this is not a civics course. What we will be most concerned with is how the Constitution is applied, how it affects our daily lives, how it governs the law, and how it is interpreted. As with every area of the law, interpretation of language is critical. Whether it's a will, a contract, an insurance policy, a court order, the language of some document is something that will be and has to be interpreted frequently. But with constitutional law, because you're talking about such a small document, and because you're talking about the interplay of that document against other laws, interpretation is extremely important. Because not only are we talking about a small document that has wide, broad application against more narrow, more detailed laws, we're talking about something that has global, national impact. So for example, if your family's having a dispute over your Aunt Mame's will, how a judge construes the terms of that will may affect you and your family members, but nobody else is really going to care. With the Constitution, how the Supreme Court interprets a specific clause of a Constitution or applies it against a law of another state could affect everybody in the nation. While most language is pretty clear and not really subject to dispute, There are other parts when the language is not so clear, or is broader, or may even include multiple meanings. When we're talking about the interpretation of language, though,
English, mother, do you speak it?
we're talking about interpretive processes. As I said before, we talked about that as being construction. In the history of the Constitution, there have been traditionally two schools of thought about the construction of the Constitution. The strict constructionists are those who think that the Constitution has to be narrowly interpreted, that it only confers very small, narrow powers to the federal government. Its first adherents were Thomas Jefferson and the Anti-Federalists. By comparison, the loose constructionists, those who favored a broader, more sweeping application to the Constitution, are the followers initially of Alexander Hamilton and the Federalists, and then, frankly, more liberal judges of today. Now, when we're talking about interpretation, when we're talking about words, typically you're going to see that the courts use the plain and ordinary meaning of the language. This isn't just in the context of the Constitution, but it is also what is frequently employed when courts interpret statutes. Indeed, when they're interpreting the Constitution versus a statute, they're often employing the plain and ordinary meaning of the terms that are used in both. In the coming episodes, we're going to be talking a lot about interpretation. I'm Jeff Henley, and with me, as always, has been Annabelle. We'll see you soon. Until then, you stay out of trouble, or the law dogs will get you.